Hey, welcome students to Political Science 475, Constitutional Law. Today we will be going over the right to counsel. Alright, so, as we saw in our last lecture, Escobedo versus Illinois established that your right to counsel begins when?
When the investigation is no longer general and focuses on you as a suspect.
Exactly. Very good. So, in Escobedo versus Illinois, it was established that your right to counsel begins at the accusatory stage of the process.
Yeah.
That is, the point at which the investigation ceases to be general and begins to focus on a particular individual, namely you, right?
Oh.
So, that's when your right to counsel begins. Why do you need counsel when you first come under suspicion of committing a crime?
Because I don't want to make a confession or give any evidence against myself or something that I deem they need to take me into custody for.
Right, exactly. And so are there a number of complicated stages that occur from questioning all the way through the appeals process? Yes, and so as the court put it in Escobedo versus Illinois, you need the guiding hand of counsel throughout all of those complicated stages. Okay, now, at the time of the founding, how complicated was the law in the United States? Very complicated or relatively uncomplicated?
Well, it depends. I mean, it was relatively uncomplicated, but...
Exactly, it was relatively uncomplicated, exactly. We didn't have nearly the number of laws that we have now. They're not nearly as complex, right?
They start to add up.
Yeah, they do start to add up over 200 years. They do start to add up. And so, at the time of the founding, quite frankly, most people represented themselves. You know, you still had the right to counsel in criminal cases, but it wasn't often used just because the law was relatively straightforward, not that complex, not that developed. We didn't have nearly as many laws. And so the right to counsel was, of course, very good to have as an option, but the thing was, practically, it was, on a practical level, it was not exercised all that often. Okay? But then over time, the law became increasingly complex in the United States, right? And reformers began to be concerned that there was a real disparity between the wealthy, who could afford very effective representation, and the poor, indigents, who could not afford effective representation. Exactly. So, reformers wanted counsel for poor defendants. So, this leads to an interesting question. Do some constitutional guarantees change depending on how society changes?
Yes.
Yeah, you can make the argument, yeah. Okay, so in Powell versus Alabama, which was decided in 1932, the Supreme Court scrutinized this claim for the first time. Powell versus Alabama is also known as the Scottsboro Boys case. And it occurred here in Alabama and was an infamous case for a number of reasons. Let's go into the details and you can begin to see why. So, 9 young black men and 7 young white men and 2 white women were riding in an open car on a freight train traveling from Chattanooga through Alabama, right? The young men got in a fight. that ended with the white youths being thrown off the train and the women claiming they had been raped by the young black men. Okay. Now, how is this going to go over in 1930s Alabama? Yeah, 1932 Alabama. How's that going to go?
Good.
Not good.
Have you read To Kill a Mockingbird?
Right. Yeah, exactly, right? So it's not going to go over well. People got into an uproar. Later in life, one of the women admitted that she had not been raped. So she was lying, yeah, there it is. So, word of the alleged rape spread. People got in an uproar, a mob gathered, and when the train reached Paint Black, police arrested the youths and jailed them in the county seat of Scottsboro. And the mob was surrounding the jail and that type of thing. So there was intense public pressure, intense outrage, scrutiny. It was a very volatile situation. So under Alabama law, the judge was supposed to appoint counsel to assist them because they were charged with a capital offense. At the time, in some states, rape was a capital offense.
It was. In Alabama it was.
Right. And just so you know, since this is constitutional law, the Supreme Court has changed that, and rape can no longer be a capital offense. Just so you know. But at the time, rape was a capital offense. So, as I said, the judge was supposed to appoint counsel to assist them because they were charged with capital offense. Instead, he assigned all the town's members of the bar to represent the accused. So, if you represent everyone, who's going to take responsibility? No one. Exactly. And so that's one of the concerns. So no single lawyer took responsibility for their defense. So, literally on the morning of their trial, a Tennessee lawyer named Roddy, who had been sent down by people concerned about the boys' plight, appeared to represent the defendants. So, literally the morning of the trial. So had he had time to question all of his young defendants and find out their story, what went on, come up with a good defense strategy, that type of thing? No. Also, if you're coming from Tennessee, do rules of criminal procedure differ from state to state?
They do.
They do. And so the judge authorized a local attorney to work with Roddy, but still, he's come down the day of the trial. He's from a different state where rules are different, laws are different. So the boys were really disadvantaged. So 8 of the 9 were found guilty and sentenced to death. This leads to the main question: do indigents have the right to counsel at government expense? Case reached the Supreme Court, and the Supreme Court mandated for the first time the appointment of counsel, but they limited their ruling. They said a lawyer must be provided in unusual situations such as those presented in this case. Let's look at what those... So this was a landmark ruling because it was the first time they said counsel needs to be provided for indigents at state expense, right? So that makes it a landmark ruling for that reason alone. But they said not necessarily in all cases, but definitely in cases like this. So was this a capital offense or a lower offense? Capital, the absolute, most severe charges possible. So yeah, you're entitled to counsel at government expense in capital cases. Also, was this a low-profile case or one where there was intense public pressure?
Intense public pressure.
Exactly, intense public pressure. And then you look at the defendants, old or young, educated or uneducated.
Uneducated, probably.
Yeah, experienced or inexperienced.
Inexperienced,
right? Yeah,
make a stink about it. Say, I want a lawyer.
Yeah, well, they're just really vulnerable, right? So they're young, uneducated, inexperienced, and like I said, 8 of the 9 wound up getting sentenced to death. So it was appealed all the way to the Supreme Court. The Supreme Court said, you have the right to counsel in cases like this. All right. Now, just on a historical note, a lot has gone on in Alabama with recognizing how poorly these young men were treated. So that's a good thing. So 6 years after Powell, in Johnson versus Zerbst, a 1938 case, the court ruled that indigent defendants involved in federal criminal prosecutions must be represented by counsel. Okay, so that's Johnson versus Zerbst. Now that's important because, again, it expands the right to counsel for indigents to federal cases. But where does the bulk of law enforcement occur? At the federal level or the state level? State and lower, exactly. So it was limited. After Johnson versus Zerbst, if you were indigent, you had the right to counsel at state expense if you committed a federal crime. But the number of federal crimes committed compared to the number of state and local crimes committed is way lower. But it did expand the right to counsel at government expense. All right. Then, in Betts versus Brady, 1942, those who favor the right of the accused hope to apply Johnson to the states, right? So you begin with getting the right to counsel at the federal level. They got that in Johnson versus Zerbst. Now they're hoping to get the right to counsel at government expense at the state level in Betts versus Brady. So here was their strategy. All right. So in Betts versus Brady, Betts was indicted for robbery in Maryland. Betts was a poor, uneducated, but literate white man, and he wanted an attorney at government expense. Maryland, like many states at the time, provided indigents with counsel only in rape and murder cases. Right? So Betts conducted his own defense and was convicted. Right? So by 1942, had the law gotten very complex in the United States?
Yes.
Yes, certainly more complex than it was at the time of the founding, right?
Yeah.
And so he said, I need an attorney to have adequate representation. And he was told no. He appealed to the Supreme Court. He asked them to apply Johnson to the states, thereby incorporating the Sixth Amendment, but the court refused. He said, basically, we're leaving this to the states to decide whether they want to provide counsel for indigents at state expense. Okay, now again, keep in mind the year 42. They're deferring to the states. If they required states to provide counsel for indigents at state expense, would that have involved a lot of costs for the state? Yes. Are most criminals indigent? Actually, yeah, most. So, in other words, if the court had ruled states have to provide counsel at state expense for indigents, that would have imposed a huge cost on the states, and the court was unwilling to do that in 1942. Right? Justice Hugo Black, our very own Hugo Black from the great state of Alabama, he dissented in that case and said Betts deserved counsel at state expense. It was fundamental and essential to a fair trial. Okay, now keep in mind, Black was fairly new on the court in 1942. He was one of FDR's appointees. He was a New Deal justice. And, he filed a dissent, but he did not carry the day. Right? Okay. 21 years later, Black had outlived a lot of his colleagues who'd been on the court during Betts versus Brady. And 21 years later, during the Warren Court, a court that was much more sympathetic to the rights of the accused, they revisited this in Gideon versus Wainwright, 1963. And this one was 9-0, right? So what does it tell you when the Supreme Court issues a 9-0 ruling on something?
They believe in it pretty heavily.
Yeah, they believe in it really heavily. This isn't going to change with one justice getting replaced type of a thing. So it's a new day. A new day has dawned, right? Gideon versus Wainwright directly overruled Betts versus Brady. Directly overruled Betts versus Brady. So let's go into the facts of the case. Gideon was charged with breaking and entering a pool room. How much money are you likely to steal from a pool hall?
Not very much.
Not very much. Bunch of nickels type of thing. Oh, wow. But so you're talking about a pretty petty crime, right? Now, Florida law provided free counsel only to those charged with a capital offense. Again, similar to Betts versus Brady. Anything less than a capital offense, no free lawyer if you're indigent. So Gideon, like Betts, was a poor, uneducated white man. He tried to defend himself, but failed. Right? And, again, in the 20 years, law had only gotten more complex. Right? So, after studying the law in the prison library and attempting a number of lower court actions, Gideon filed a petition for a writ of certiorari with the U.S. Supreme Court. So pretty ambitious. Studied law on his own in the prison library. And his writ of certiorari was handwritten on prison note paper. Usually cert petitions, writ of certiorari petitions to the court are very formal. They have to follow very strict guidelines to make sure that they're legible and readable and standardized. But he was filing this in the form of a pauper, someone who doesn't have any money. So they kind of cut you some slack on those guidelines, right? So it was handwritten on prison note paper, goes to the Supreme Court, and they granted cert. Out of all the cert petitions, said they get about 8,000, 9,000 a term. Don't know exactly what it was in the 60s, but it's probably similar. And they grant cert to this one. Now, because Gideon was without counsel, he was in jail. The court appointed Abe Fortas to represent him. And Abe Fortas was later appointed to the U.S. Supreme Court. So,
Wow.
yeah, I know. So it's kind of one of the neat little details. So he had very good representation. Future Supreme Court Justice was representing him. Also, Abe Fortas, just so you know, was a Johnson appointee. And he and Johnson were very close. And Johnson used Abe Fortas as a confidant. And a lot of people kind of question that, because we believe in the separation of the three branches. Yeah, exactly. But anyway, just so you know, that's who Abe Fortas was. Is very trusted, very well respected judge. And yeah, at the time he was appointed to represent Gideon. So interesting. Now next, 22 states filed an amicus curiae brief. Remember we said that's a friend of the court brief, which was written by Walter Mondale. He was then the Attorney General of Minnesota. He was later a senator and U.S. Vice President to Jimmy Carter, supporting Gideon's argument. So Gideon goes from being this guy sitting in jail to being represented by a future Justice of the Supreme Court and having an amicus curiae brief written on his behalf and on behalf of the states by a future Vice President of the United States.
Put that on your resume.
Yeah, exactly. And Walter Mondale actually was the Democratic nominee for president in 1984. But he was Jimmy Carter's vice president. So, why do you think it's important that 22 states filed an amicus curiae brief supporting Gideon's argument?
Because it showed that they were willing to provide the expenses of defending and providing defense to people.
Outstanding. Excellent. That's right. They were willing to incur that extra expense. They'd reached a point where the states realized this is just something we need to do to guarantee people fair and effective representation. So, the Sixth Amendment provides in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The court said a provision of the Bill of Rights, which is fundamental and essential to a fair trial, is made obligatory upon the states by the 14th Amendment. Right? So, in Betts, the court concluded that the guarantee of counsel is not one of the fundamental rights. But the court in Gideon versus Wainwright concluded it was fundamental and essential to a fair trial. So, do you think the right to counsel is fundamental and essential to a fair trial?
Yes.
Absolutely. If someone cannot afford an attorney, should they be provided with an attorney at state expense?
Yes.
Yes. What's that?
It's in your Miranda.
Yeah, exactly. Basically, with this case, the court is telling the states you're going to have to provide counsel for indigents at state expense. And that's going to be a large expense, but you're going to have to incur that expense. So, get yourselves prepared for that.
Yeah.
Right? Okay. Now, let's talk about the nature of the offense. Remember, Powell started with, you have the right to counsel in capital cases. Intense public pressure, poor, uneducated, inexperienced, young defendants, intense public pressure, that type of thing. Then, Johnson versus Earps, you're entitled to counsel in all federal cases. Federal cases tend to be pretty severe, right?
Mm-hmm.
But then in Gideon versus Wainwright, we went down to breaking and entering a pool hall. Okay, and they said you're entitled to counsel in that situation. So the question became, well, how low are we going to go, right?
Petty crimes.
Yeah, petty crimes, jaywalking, I don't know. So whether Gideon should be applied to offenses less serious than a breaking and entering charge was addressed in Arger Singer versus Hamlin, 1972. Arger Singer versus Hamlin. And this was an appeal from a man sentenced to serve 90 days in jail for weapons violations. Okay, 90 days. Would you want to serve 90 days in jail? No. Would you want to serve 1 day in jail? No. What could happen to you in 1 day in jail?
Me? Quite a lot. I mean, like barely breaking 100 pounds. Okay.
Yeah, I know. I would not want to spend 1 day in jail. Things could happen to you in jail that you might never recover from psychologically. Anyway, it's bad. I don't want to spend 1 day in jail. So, in Argersinger versus Hamlin, the majority developed the loss of liberty rule. Whoever is deprived of liberty for even 1 day is entitled to an attorney. So that's the guideline. If there's any danger, risk, possibility that you'll go to jail for even 1 day, then you're entitled to an attorney at government expense. Now, the court, in later cases, said, well, what about those situations where, where it says a year in prison or a $5,000 fine? It looked at situations where the prosecutor said, okay, we're not going to go after any jail time, just the fines. And what basically came out of those cases, don't worry about them, was the loss of liberty rule still applies, right? If there is any danger or possibility that you're going to be spending 1 day in jail, then you're entitled to representation at government expense, counsel at government expense, if you can't afford it. Always got to provide that caveat, right? So, what do you think of that decision?
I think that's a good decision.
Yeah, good decision.
Because also, you never know when you get into a trial, it's whatever you're up and going for, situations may change, evidence can come forward that can be even a little bit more serious than we thought,
Yeah, exactly, right? And so, any possibility that you could go to jail, you're entitled to counsel at government expense. All right. Now let's talk about Gideon and the appellate stage. Okay, so you have the right to counsel at your original trial. But then the question came up, do indigents have the right to counsel, to appointed counsel, if they can't afford it, throughout the appellate process? Right? So, in Douglas versus California, 1963. So that's the Warren Court. Very sympathetic to the rights of the accused. The court held that the right extended through the first obligatory appeal. Now, obligatory appeal means that the appellate court has to look at your appeal. They have to consider your appeal. You're entitled to have them look at your appeal, right? So what do you think about that ruling? Good ruling, bad ruling, makes sense?
Yeah, it makes sense.
Yeah, it makes sense. Because again, the spirit of Gideon is the law is complicated. There are a number of stages, and the appellate process is actually one of those stages. It's the final stage, but you need counsel to guide you through that process. Okay? And so again, that's Douglas versus California, 1963. That's a Warren Court ruling, and the Warren Court is generally very sympathetic to the rights of the accused. Then, in 1974, which is the Burger Court, and remember, in 68, Nixon ran a law and order campaign, and he appointed 4 new justices, Blackmun, Berger, Powell, and Rehnquist. And they were expected to be law and order types. We're through coddling criminals. We're through with, all these rulings that protect the rights of the accused. And it's time to get tough on crime. He ran a law and order campaign. Exactly. So, in Ross versus Moffitt, 1974, this was a Burger Court ruling. The court refused to extend the right through the discretionary review stages. Okay? Now, in their defense, in the court's defense, when you're originally charged with a crime, you need an attorney, right? Mm-hmm. That's what the court said in Gideon. Then, in Douglas versus California, you're entitled to an attorney through obligatory appeals. That's where the appellate court has to take your case, right? But in discretionary appeals, depending on the court system and the different states you're in, through discretionary appeals, the appellate court doesn't have to take your case. So here's my question for you. If the court does not have to take your case, then are you really entitled to representation at government expense if the wealthiest person in the world is not even guaranteed that the court will review their appeal? No. That's what the court reasoned, right? Is they said, look, even the wealthiest person isn't guaranteed that an appellate court with the discretion of whether or not they take the appeal is going to take their appeal. The wealthiest person in the world isn't even guaranteed that, right?
Well, they're probably going to get it,
but I don't know. I mean, maybe if you're like Bill Gates or Warren Buffett.
Publicity.
Yeah, you probably would. But you understand the reasoning, right?
Yes.
Right. And so the justices of the Burger Court failed to overrule revolutionary Warren Court decisions. But as Ross versus Moffitt shows, they shut the door on further expansion of those rights, right? So, yeah, you have it through the first obligatory appeal, Douglas versus California, but not necessarily discretionary appeals, Ross versus Moffitt, right? Mm-hmm. So, to make sure we're all clear on these things, does the U.S. Supreme Court have discretion over which cases it takes and which cases it does not take?
Yes.
Yeah, exactly, right? So that's why you're not necessarily guaranteed counsel through those discretionary appeals. Okay, now, really quickly, well, kind of quickly, let's talk about money, justice, and effective representation. The court has recognized that the right to counsel is the right to effective assistance of counsel. So let's just discuss this for a minute. Um, where do you think the best and brightest attorneys wind up going? Working for public defender offices or Wall Street?
Wall Street.
Wall Street.
New York.
Yeah, you're like the best attorneys from the best law schools usually don't wind up working for public defender offices, that type of thing. So the concern is, the wealthy still can get way better representation than the poor, right? So again, the classic example of that was O.J. Simpson, when he was accused of murder. And he assembled what came to be known as the Dream Team, the best defense attorneys out there. And they got him off, right? But he was still found guilty in the civil suit. But they got him off of the criminal charges. He didn't, he wasn't found guilty of murder, and he was let off in the criminal case. So anyway, the question comes up, what if, especially a poor person, has not received adequate representation, sufficient counsel, effective counsel? So the court took a look at this in Strickland versus Washington in 1984, and they laid out a test for this. The first is the defendant must show that counsel's performance was deficient. This requires showing that counsel made errors so serious that counsel was not functioning as the counsel guaranteed by the Sixth Amendment. Mm-hmm. So in other words, your representation was so bad, you don't even deserve the title attorney. You don't deserve the title counsel. You you just thoroughly botched the job, right? You don't even deserve to be called an attorney. Yeah, you don't deserve the title counsel. And the court said some interesting things here in this case. It's kind of an interesting case. They said, basically, in hindsight, a litigation strategy looks bad when you lost, right? But until you know whether you're going to lose or not, in the heat of battle, do a lot of litigation strategies look reasonable? Yeah. You got to give a verbal response. I can't see you nod your head.
Yes.
Yes, right? So, during, like I said, during the heat of the battle, when your trial is going on, a wide range of litigation strategies may seem acceptable or viable or reasonable, right? But when you lose, is it tempting to look back and say, that was a terrible decision, that was stupid? Yes. And so what the court is saying in this case basically is, once you lose, all litigation strategies are going to look stupid or bad, right? You lost. So, I mean, I'm exaggerating a little bit here. But they're going to say, it's really tempting after you've lost to look back and say that was a horrible litigation strategy. We should have gone another route. We should have tried something else, right? Yeah, that was a mistake. But And so that's why they adopt this other standard, the standard I just gave you. Counsel made errors, not just chose the wrong litigation strategy, made errors so serious that counsel was not functioning as the counsel guaranteed by the Sixth Amendment, right? So, to illustrate how sometimes litigation strategies in hindsight seem very stupid sometimes. Larry Langford, former mayor of Birmingham.
Larry.
Yeah, Larry Langford. He was accused of all kinds of things, right?
I remember this. This is the Lemmings cartoon.
Yes, definitely. He was accused of all kinds of stuff. Taking bribes. Yeah, you give me this and I'll give you that. Okay, sounds good. There's a lot of that type of stuff going on. And he just had a list of charges against him that was forever long, right? Well, in his closing arguments, his defense attorney came out in a jacket with dollar bills all over it.
Oh, I remember you telling me.
Yeah, I know. I told you guys about this when it happened because I'm just like, am I reading this correctly in the paper? But his defense attorney came out with dollar bills all over it. And I forget if they were taped on or pinned on or drawn on or whatever, but there were dollar bills all over his jacket. And he basically preened in front of the jury and said, look at how tempting all this money is. My client is only human, and how could my client be expected to turn down all this money when it's offered to him in such a tempting fashion, right? Yeah, so basically the argument was, how could my client be expected to refuse all these bribes?
You do.
Yeah, which is just a horrible argument, right? But, so anyway,
stuff like that makes me think I could pass the bar.
Yeah, exactly. But Langford tried to say, hey, my counsel wasn't effective. And number one, he wasn't indigent, right? Mm-hmm. And so when it's counsel that you've hired, that's going to be a little less persuasive. Say, oh, my counsel stunk. Well, then why'd you hire him?
Paid you money.
Exactly. The next thing was, if it had worked, I mean, obviously they thought it was gonna work. That's why he did it.
Yeah, good strategy.
Yeah, who knows? But anyway, so next thing, the defendant must show that the deficient performance prejudiced the defense. Right? So in other words, you have to show it made a difference in the defense. It made a difference in the outcome. A lot of the time, counsel makes mistakes, but it's not gonna make any difference.
Yeah.
So to continue with Larry Langford's case, it was so obvious he was guilty that, like I said, there were all these charges against him. The jury goes back, and they come out after a relatively short period of time, right? And they said, we find the defendant guilty of, all these things, right? Well, then he tried to appeal it, and his argument was the list was so long, they didn't even have time to read all the charges. So, I know, these are creative arguments. Yeah. He's like, I was guilty of so many things that even taking the time to read them would take longer than they spent back there. They couldn't have read through them all
Buddy,
and
that's
voted
a
on.
bad sign.
I know. It's a bad sign. And the reason they didn't have to read them all is it was so obvious he had done them all, And that's why they're just like guilty, guilty, guilty on all those things. And but that was the strategy he attempted. And there it is. So here's the point. Number 2. The deficient performance prejudiced the defense. Even if Larry Langford's attorney comes out in a jacket with dollar bills all over it, is he going to be found guilty?
Yeah.
Yes. Right?
Guilty boy.
Why was he found guilty?
Because he did it.
Because he was guilty, exactly. You have all these witnesses, all this evidence, just obvious as can be, and so he was guilty. So, well, that wraps it up for the day. Really quickly to review, right to counsel. Make sure that you know very well Powell versus Alabama. It's known as the Scottsboro Boys case. Very, very famous. Johnson versus Zerbst extended your right to counsel to federal cases. It's important for that reason. Betts versus Brady, the court refused to apply it to the states. Gideon versus Wainwright, they did apply it to the states. And again, Gideon versus Wainwright, there are landmark rulings, and there are landmark rulings. And Gideon versus Wainwright is one of the most famous Supreme Court rulings out there. As is Powell versus Alabama, actually, as well. Argersinger versus Hamlin developed the loss of liberty rule. Douglas versus California, you're entitled to counsel if you're indigent through the first obligatory appeal. Ross versus Moffitt, not entitled to counsel through discretionary appeals. And Strickland versus Washington went over when counsel is so ineffective that you're not guaranteed the counsel that the Constitution does guarantee. So, well, it's been another fun session. We'll be uploading some more content in another day or two. Take care, and I hope you guys are doing well, and stay safe. Take care. Miss you guys. Wish you were in class. Bye-bye.